Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Our partners are experienced trial attorneys who've been board certified in family law by the Texas Board of Legal Specialization.
Thanks for tuning into For Better, Worse, or Divorce podcast, where we provide you tips and insight how to navigate divorce and child custody situations, particularly in the state of Texas. So I'm Jake Gilbreath, one of the managing partners of Walters Gilbreath. Today I'm with my business partner, Brian Walters, and we are going to discuss the concept of separate property in Texas. We're going to talk about what qualifies as separate property, how it's proven in court to either a judge or a jury, and why it can, of course, become a major point of contention in a divorce. And we'll also try, if we have time at the end, to try to unpack some of the common questions and concerns we get from clients, particularly when they're coming in on intake about what is separate versus community property and how it's going to affect their case. So, Brian, before we started talking and recording this podcast, we were making the comment, which is correct, that we could probably present and talk for hours upon hours about separate property in the state of Texas. I think probably when it comes to the property aspect of a divorce, when you see cases go to trial or when there's lots of litigation or contention, I think a lot of times it's driven, most of the time, it's probably going to be driven by a separate versus community question. Sometimes you have valuation disputes, right, that can lead to different experts having different opinions and making cases difficult to settle. Sometimes you have some fraud claims, reimbursement claims that make cases difficult to settle. But separate versus community can be a very common issue, particularly in the state of Texas, and can lead to making cases a little more difficult to resolve. Do you agree with that?
I agree. It's confusing and complex, and there's plenty of areas that there can be reasons to litigate. I agree.
Yeah. Well, let's talk about the basics, right? Starting with the basics of what is separate property in the state of Texas. So just the raw definition, turning to section 3.001 of the Texas Family Code. A spouse's separate property consists of 1, property owned or claimed by the spouse before marriage; 2, property acquired by the spouse during marriage by gift, devise, or descent; and 3, the recovery for personal injuries sustained by the spouse during marriage, except any recovery for loss of earnings capacity during the marriage. Right. So I usually rattle off 3 relatively quickly when I explain separate property to clients. I have had cases, I don't know about you, Brian, I've had cases where you do see separate property from the recovery for personal injuries, which is not as common, but I've seen that in some cases pop up over the years. Have you seen that as well?
Yeah, I've got one right now that's got that issue, but I agree they're pretty rare. Even if they existed, they're usually not a large amount, or they've kind of dissipated or been spent over the years, or it's unclear whether it was for lost wages or personal injury or things like that. All those things can muddy the waters.
Yeah, just pause really quick. I was going to make that point. Is practice tip for anybody listening out there, or any personal injury lawyers that are out there. It's a lot of times people come to us and they've received a personal injury settlement, and the lawyers have not broken it out of what's for loss of earnings, what's for property damage, what's for pain and suffering. And like we'll talk about in a second, everything's presumed community property, unless you prove that it's separate. So you could have problems there if it's not handled correctly. But like you were saying, Brian, it's not what you see most of the time. Typically, you see property, people come, their separate property claims are property owned before marriage, or property by gift, or inheritance. Inheritance, a big one. Owned before marriage, a big one. Almost, I would say 99.999% of divorce petitions filed in the state of Texas have a claim of separate property. Sometimes people freak out when they see that, when they've been married 20 years, and they go, what do you mean? What does he mean or she mean that she has separate property? And I would say everybody's got a little bit of separate property, right? Like your wedding ring is your separate property, little gifts and stuff, that's your separate property. And so it can range from that, right? My wedding band is my separate property, all the way you can see multi-million-dollar separate property claims. You can see a $20 million estate and 99.9% of it's separate or claimed to be separate, depending on the situation. So I guess, Brian, talk to us now that we've sort of defined separate property. Why is it important to what happens if I prove that something's my separate property? We'll talk about burden of proof in a second, but why am I trying to accomplish proving what my separate property is in a divorce?
Because you get 100% of it, and the court doesn't have any discretion about it. They have to give you 100% of it if you prove it's your separate property versus dividing it in some nebulous manner in a fair and just manner. So that's a big deal.
Yeah, and it's like you're saying, the court is without discretion. It's in the Texas Constitution. A court can't divide you of your separate property. So if I prove it, even if it's a quote unquote unfair result, right? We've been married for 20 years and 99% of it's my separate property. Maybe it's because I formed a business 2 seconds before I got married. And then now it's worth something. So now it's worth substantially more. That's where a bulk of our wealth is. If I can prove it by clear and convincing evidence, which we'll talk about in a second, it could lead to an unjust result, or what some people would perceive to be an unjust result. And the court can't sit there and go, well, that's not fair. I'm not going to do that. I don't care that you've proved that it's your separate property. The court, she's going to have to, if you prove it, your court's going to have to confirm that is your separate property. So the way I describe it to clients, and whenever coming in the consults and talking about how divorce works, I always try to get them to start thinking about a spreadsheet, right? And I always say, what we're going to do is put everything that you own on a spreadsheet of substance, right? House, vehicles, brokerage accounts, 401ks, whatever, is all the way down to furniture. We're not going to totally put like the lamp on there, but we're going to put what you own, substantially what you own, on the spreadsheet. And then question number one is it community or is it separate? Everything, the family code says, everything is presumed to be community property. In other words, we're presuming that we're going to divide it up. We're presuming it's going to go in that spreadsheet. But if I can prove something is my separate property, essentially falls off the spreadsheet, we call it below the line. So it's basically not being divided, but it falls off the spreadsheet if I can prove that it's my separate property. Of course, in step 2 is what's the value of everything. Step 3 is of the community. And then step 3 is let's divide it. So, Brian, how do I go about, first of all, what's my burden to prove something is my separate property, and how do I go about doing that?
Yeah, the burden's clear and convincing evidence. So, it would be nice, I think, if they gave us a percentage, right? So the lowest burden of proof is preponderance of the evidence, which is for most things, I'd say that's basically 51% proof that you're more likely than not, you've shown that. The one in criminal law that you hear about is beyond reasonable doubt. That's not defined as a percentage either. I've always thought that's probably 99% or 95%. This is clear and convincing. I don't know. Again, we don't have a number. I've always thought it's something like 75 to 80% probably. You're pretty darn sure. You don't have to remove all reasonable doubt. You probably just have to remove major doubts or significant doubts. So it's a bigger burden to get over than we're used to in court, where we're most of the time in family law just doing the 51% preponderance of evidence. So that's a higher level of proof. And I think the second question was about, how do we prove it, or what are the kind of things that we use to prove? So it depends a lot on the type, right? You use the example of forming a business before the marriage, although forming can be an interesting debate. But let's say that it's clear you did, that might be the incorporation papers, or if you have a piece of real estate that you own before the marriage, it'd probably be the deed, the title and deed and closing document showing when you purchased it. So those type of things can be relatively straightforward to show or prove, partly because they stick around forever. For financial things like accounts, generally you'd want to have the statement. Let's say it's a 401k that you had before the marriage that you've continued to add to, which is pretty common. We'd want to see the statement, the month before you got married or right before you got married, and then we'd probably also want to see, if possible, all of the yearly or monthly statements since that time to tell us what's occurred. So those are examples of of the type of proof that you would have in common cases in this
Yeah.
situation.
And what's consistent about all the examples you gave, Brian, is that it comes with documentary evidence, right? There are situations, I think, where you can prove separate property via testimony, right? It's like my mom gave me this car, gave me this ring or the boat. I had a client once gift a yacht, and that had testamentary evidence that he gave the wife the yacht. I think there's also a picture with a bow, giant bow on the yacht, which kind of really supported the gift claim that wife had for the yacht. Um, but sometimes it's testimony, right? Somebody gave this to me, and then the person that gave it, the donor, comes in and testifies and said, "Yeah, that was a gift." And so sometimes you can prove it with testimony. Most of the time, you're going to be looking for documentary evidence, like you were saying, Brian, deeds, bank statements, those types of things. And in some cases, most cases, I would say it's required. And there's substantial case law talking about the requirement of written proof, documentary evidence is not just enough for me to say, "Oh, I had this $20,000 before I got married, and then I think I put it in my Chase bank account, and it sat there for a little bit, and then I remember transferring it to Wells Fargo, and then I pulled it out in cash and had that for a little bit, and then I put 10,000 in the safe, and then I pulled it out. My brother held it for a little bit, and then now he purchased a vehicle for me with that $10,000, and so the vehicle's my separate property, right? That's not going to carry my burden." Which is, I think, there's cases that talk about mere testimony is the actual phraseology used in the case law. Mere testimony is not enough to prove separate property. And to your point on Brian, on 401ks and retirement accounts and stuff, Brian, it's talking about not just the monthly statement before marriage, but um, every single statement during marriage. The reason why that's important, and again, we could ramble on about this for 5 hours. There's hours upon hours and pages upon pages with CLEs and presenting and cases on separate property. But generally speaking, it's important for people to know that in Texas, income off of separate property is community property. Okay, that's a very important principle to understand on separate property. And so it's not just enough for me to sit there and go, "Here's my brokerage account statement from a month before I got married. It's got $100,000 in it. And here's my broker account statement right now, and it's got $150,000 in it. Therefore, 50's community, 100 separate." That does not carry your burden of proof, because that brokerage account, even if you haven't contributed to in the marriage, is going to have interest and dividends, which is income, which is going to be reinvested and do what we call that. You hear a lot of people hear the phrase commingling, right? There's community property commingling in that account. And if you can't prove, which by clear and convincing evidence, if you can't prove what part of that increase is community versus separate, it's all community, it all goes on the spreadsheet, it all gets divided. So it's important to have documentary proof on that. The other general principle that I think it's important for people to understand. So principle number one, I guess first start with what separate property is. A very important principle number one, that community income off of separate property is community property. A very important principle number two in the state of Texas is the increase in value in separate property remains separate property, right? I have a house that I own before marriage, so it's my separate property. I've got the deed, I can prove it. And say it was worth $500,000 when I got married. 10 years later, I get divorced. It's now worth $1.5 million because of the market increasing. That increase is it remains with a separate property. That house remains my separate property. Maybe there's reimbursement claims in the house, which we could spend another 5 hours talking about reimbursement claims. But the increased value in separate property remains separate. It's not that in every single state in the United States. It is like that in Texas. And that, Brian, I don't know about your experience, but that can be surprising to people, and it can lead to arguably unfair results in a marriage. What do you think about that?
Yeah, I agree. I mean, to use the stock example, if you have let's say a bunch of, I think, Apple stock, for example, that generally doesn't pay dividends or interest or anything like that, versus a utility stock, which are heavily dividend based, let's say over the course of a marriage, you started with $1 million of each one. And then at the end of the marriage, there's now $2 million in the account. Apple doubled in value. The other one paid out another $1 million in dividends. Well, if you had the Apple stock, it's all yours. All $2 million is your separate property. If you have the utility stock that's now worth $2 million, if you reinvested the dividends, now, well, millions separate property, but half of it's community property. So it's a big deal about what type of assets you have and how they grow and those type of things. And nobody really thinks about that, I suspect, when they get married or if they get a gift or an inheritance. You really don't even control it, right? You just get what you get. But it can make a big difference at the end. So
Yeah. Well, in approaching these cases, one of the most important things, unless it's just something so simple like I owned a house before marriage and here's the deed, I formed a business before marriage, here's the formation documents filed with the Secretary of State or the partnership agreement before the marriage, or here's the gift letter from, unless it's something that straightforward and simple, I would say in almost every single case, you're going to be hiring a forensic accountant to do what we call tracing, where you're essentially trying to go through the documentary evidence and have an expert witness, a forensic accountant, identify what is separate and what's community, and so that way you can carry your burden of proof. And I will say, as I was taught as a young associate, that clients will, and understandably so, arm wrestle a lot about the idea of hiring a forensic accountant very early on in a case, which I get. It's an expense in a divorce. It can be a big expense in a divorce. Sometimes people are spending more money on forensic accountants than they do on their divorce lawyers, depending on what we're doing. And there's a reticence from clients to do that, which I understand because, again, it's an expense and it's a lot of work. It is really hard to both settle a case and almost impossible to litigate a case without an expert witness, right? If you have a complex, a separate property claim of any level of complexity, even a tiny bit of complexity, you're going to need to have a forensic accountant. We could do a whole other podcast on forensic accountants, but you're going to need a forensic accountant to tell everybody, what's separate and what's community. I mean, at the end of the day, if the trace is done correctly, it's just data entry. I mean, it is what it is for like the 401k example that we were giving. Sometimes there's judgment calls or differences of opinions in a trace of separate property. That's pretty rare, though. Usually it's just this is what the documents say. It's just a matter of going through the documents and identifying what's community and separate and providing an opinion. And I'm not going to do that. I guess I could. I wouldn't pay my hourly rate or Brian's hourly rate to do that. We're hired to litigate the case and provide advice to the clients and present the claim. But the forensic accountant's the one, he or she's going to be going through and tracing it. And then if you have a solid trace, it is what it is, right? And it's much easier to settle a case as opposed to going to mediation without forensic accountants and saying, well, guys, I think my separate property is this, and I'm pretty sure I'm going to be able to prove it. I haven't proved it yet. I haven't done the work, but I'm going to get there. And so let's settle the divorce now. And some people can do that. That's hard. That's really hard. And so while it is an expense to get a forensic accountant, it's more of an expense where we sit around talking about what we might be able to prove. What are your thoughts on that, Brian?
Yeah, I agree. I mean, our roles as advocates, we're not. I mean, if a forensic accountant, generally, by the way, there are not that many of them, and they're the ones that do exist and that are reputable. Their reputation in a courtroom and to other lawyers is really important to them. It's also their licensure can be affected by things, so they can't just start making things up or leaning in one direction consistently, or they'll lose their reputation and potentially even their license. Versus if we do the trace that's our role actually, is to advocate. So it really puts us in a difficult situation and an impossible one. Plus, you and I are not CPAs. We wouldn't know how to do that. I mean, sure, we could probably do it, especially a simple trace, but yeah, it's just not proper. And I agree with you. It can be a difficult conversation with clients. I had that conversation with 2 different clients yesterday, and why should I have to spend money to prove what's already mine? It's my separate property. Well, I think we've explained that in this discussion so far, but it's if your lawyers recommend it, it's probably worth doing.
Yeah, and I can give example after example, war story after war story of times where we've been on the side where somebody hasn't carried their burden of proof and they're coming into trial and they haven't retained an expert, or their expert messed up the trace or what have you. And then us being good advocates are going in there and saying they haven't proved it. They haven't proved it by clear and convincing evidence. So it's all community property. It all goes on the spreadsheet and we're dividing it up. And so it can have devastating effects on your case if you don't trace it, or if you hire somebody, because they're not everybody's good at what they do. If you hire somebody that doesn't know what they're doing and the trace is done incorrectly. So it's a conversation, thinking from the client's perspective. The second it comes out that maybe I have some separate property that I need to prove, you need to have that conversation with your lawyer, about a forensic accountant. And, frankly, you need to have the conversation with your lawyer or who you're thinking about hiring of, have you litigated this before or dealt with complex separate property issues? Because not everybody has. And sometimes the lawyers are not handling it correctly, or don't understand the problems that they have. And I could, again, we're not going to just sit here and tell war stories, but there's a prominent case that we did out of this office a few years ago that, essentially we busted a trace done by an uh, expert in quoting marks, but expert on the other side, and went up on appeal, and our position was affirmed on appeal. The expert on the other side got the burden of proof wrong. I mean, that's how he started his testimony, was saying it was preponderance of the evidence rather than clear and convincing. And it was kind of all downhill from there. And the lawyer who had that expert should have been able to say, my expert doesn't even know what the burden of proof is. I've got problems here, that I need to go fix it, or find somebody who knows what they're doing. So from the client's perspective, have that conversation with your lawyer about whether or not he has litigated these types of cases before. Well, last thing I'll say, again, we could talk for hours. Last thing I'll say before we turn to some common questions that we get is it's surprising to people, but it's good to know that this issue can be presented to a jury. It's one of the jury issues that can be presented in a divorce in the state of Texas if a proper demand is made. And that's really surprising to some people, particularly lawyers who practice outside the state of Texas, that we could have 12 or 6, depending if you're in district or county court, 12 or 6 citizens of your respective county deciding whether or not you have met your clear and convincing evidence burden of proof and proving your separate property. So that's just something out there that's important to know, and a strategic point that needs to be discussed with your lawyer, whether or not you're presenting a separate property claim or defending against a separate property claim. Let me ask some kind of basic questions, Brian, but we get a lot in consults, or we hear a lot from the other side. Does it matter if something's titled, how things are titled? For example, if I come to you and say, well, I've got a bank account, I've kept this bank account in my name only all through the marriage, so it's my separate property. Does that matter?
No, just whose name on it doesn't really matter. Now, I guess I would clarify that a bit. If let's say you had a home in your name that you owned before the marriage, and then you later put your spouse's name on it, that's going to raise questions about, was it a gift? What was the intent? That type of thing, and that could be an issue. And I suppose you could say the same thing about a bank account that was once in your name that was your separate, and then you added your wife to it or whatever. But just having it in your own name is not going to get you over the hump.
Yeah, calling something mine, or putting it just in my name does not make it my separate property. I think another common thing that I hear from consults a lot, from the other side, is somebody going, well, it's commingled, so it's all community, it's all commingled. And commingled, I think, kind of gets overused, because it is true. If I've got an account with both community and separate in it, presumed to be community. And so if I can't pull out my separate, then yeah, it's commingled, it's all community. But, if you can line item trace it, like we talked about with forensic accountants, the account may be commingled, but we can then go trace and figure out what's separate and what's community with proper documentary evidence, which is a lot easier. These days, to sound old, it's a lot easier than maybe 15 years ago, 20 years ago, because everything's electronic, right? It used to be you had clients, if you're going to prove a separate property claim, you have to go get the physical bank statements or get something on microfiche or something, or maybe a bank doesn't have statements going back as far as you need to prove your separate property. And it's a lot easier now because things are electronic. It's a lot easier to get bank statements. It's a lot easier to trace. So commingling is a thing, but that's where you have your forensic accountant do line item tracing. So I guess last, Brian, do you ever have clients come in or potential clients come in that maybe they're not thinking about a divorce, but they are um, looking to protect their assets, or they're having an inheritance, for example, coming in, and they're looking for advice of how to um, shield it in case there is a divorce, or I guess there's probate issues there, community versus separate. Do you ever do those consultations?
Yeah, quite a bit that comes up, and it could be the other way around. Hey, my wife got a big inheritance, and she dropped it into the joint checking account. What does that mean? So, those things do come up, and yeah, I mean, we advise them. I mean, generally speaking, if you get an inheritance or a gift or something like that, yeah, it probably. I mean, I think that's right. Try to keep it in an account just in your name. And we just said earlier, just keeping something in your name by itself doesn't automatically mean anything, but that's a good start. So there's no confusion about the intent behind it if it does start to get moved around, for example. But yeah, it's a complex issue. You could also do a postnuptial agreement if you're married, or a prenuptial agreement that address these kind of things ahead of time. And you can make whatever rules you want to with that, but that's a discussion for another day on another podcast. So another long discussion.
Yeah, like I say, it's a very broad overview. Every single case has its different complexities. It needs to be a conversation in virtually every single divorce consult. Because like we started by saying, like we started the podcast, almost everybody, if not everybody, has a little bit of separate property. And so it needs to be addressed whenever you're going through a divorce. But that's a broad overview. We hope that's helpful. So that's what we're going to do for today. As always, if you like what you've heard today, please do us a favor and leave a review. We appreciate all feedback, especially when it helps us better the podcast. If you have any questions about what we've talked about us, about family law, or just you're interested in talking to one of us about your family law situation, you can reach out to us at podcast@waltersgilbreath.com. You can find us online at www.waltersgilbreath.com. Again, I'm Jake Gilbreath. I'm joined by Brian Walters, and thank you all for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.